Welcome to Case by Case, a podcast brought to you by Zyla Floyd Sadkovich. You have today only one of our co-hosts, Luke Sadkovich. Callum's otherwise caught up, but I am very pleased and excited to introduce one of my partners, Joe Gosden. Welcome, Joe.
Thank you, Luke, and thank you for having me on. It's lovely to be here.
Yeah, good stuff. Good. It's always good to hear another voice on here. So thanks for coming along. And we've got a great case to talk about today. This is a case from the Commercial Court in England. Judgment was given on the 28th of April this year, 2022. It's a decision from Mrs. Justice Mulder, and the parties involved are the claimants, UniCredit Bank claimant, UniCredit Bank, and Euronav as the defendant. And yeah, we're going to be talking about whether a bill of lading springs to life when there's an ovation and not an endorsement. It's an interesting one, not one that we would come across all that often, I dare say, Joe.
No, not at all. And it arises out of quite an unusual set of facts. And it's worth actually stripping the case back slightly and considering why this dispute has arisen, because that's actually what makes it slightly odd and what leads to the bill of lading regime being tested in this way. The claimant here is, as Luke has already pointed out, a bank. And the bank is a claimant because what it is trying to do in reality is enforce under the financing package that it put in place. So UniCredit had, for better or in their case for worse, decided to give a trade finance package to the people who were going to be receiving the cargo here, the buyers, Gulf Petrochem FZC, or we're going to call them Gulf going forwards. As the judgment very politely puts it, they entered into, I think, what they call a liquidity distress, which was touching on fraudulent behaviour. And presumably there is a broader picture here where UniCredit lost an awful lot of money. What happened here is that there was a cargo that had been loaded by BP, and it had been loaded on board a tanker called the Sienna, which was chartered by BP from Euronav. That cargo had gone out on the water and it had been discharged by ship-to-ship transfer into two other tankers. Firstly, I think it's called the Cutch Bay, and secondly, called the Prestigious. There's no dispute of fact, those transfers took place, that's what happened to the cargo. The problem is that the financing structure UniCredit had put in place saw them have their position washed out, if you like, by the sub-buyers, so the guys that Gulf were selling to, paying Gulf and the money coming up the stream to UniCredit. Gulf essentially went pop, and so the bank was left looking at its security package, trying to work out what it could do. And one of the things that it had done, part of its security package, was to take, I think it was a pledge and an assignment. Yeah, pledge and an assignment over all of the rights under bills of lading issued in respect of financed goods. So here we've got some financed goods. They're on board the Sienna and the bank hasn't been paid. So what the bank is doing is it's looking to the rights that it might have under the bill of lading. That bill of lading was issued. It was a two-order bill issued by owners in the usual way to BP as sellers and shippers. And what makes it slightly odd is that charter party was actually novated, so this is the charter party between Euronav and BP, was novated to Gulf on the 6th of April 2020. So that is after the bills of lading have been issued and whilst all this was taking place. The reasons for that novation happening aren't fully clear and aren't necessarily important, but the effect of that legally is absolutely crucial. That's because one of the oldest adages in shipping litigation is the idea that a bill of lading that is in the hands of a charterer is a mere receipt, and that actually the contract of carriage is contained elsewhere. And the really interesting thing about this case is that it tests the basis for that in a lot of detail.
Exactly. And thank you for that intro, Joe. This is one of the more factually complex cases that we've done in a while, actually. So it's good to get into a real meaty one today. Now, the key issue, as Joe has highlighted there, is what is the status of a bill of lading when it is in the hands of the charterer? Now, there's plenty of law on this to say that the bill of lading is a mere receipt when it is in the hands of the charterer. So it's a holder of the bill of lading, but also a charterer of the bill of lading. And the contract between that holder charterer and the owners is the charter party. It's not the bill of lading. So bill of lading, for many of you listening in, will know that it typically serves three roles, has three kind of uses to it. It's a receipt, a mere receipt of the goods. It's also a contract of carriage, and it's a title document, title to the goods as well. When that bill of lading is in the hands of the charterer, it is only a receipt. It is not the other two functions of the bill of lading. But what's interesting is this concept of whether the bill of lading has been issued. Okay, the owners, the carriers have issued the bill of lading. It's in the hands of the shipper charterer, but if you like, it's only a receipt. It's not yet a contract. And the concept and what the authorities refer to is that the contract of carriage attains the status of a contract or springs to life as a contract on endorsement. So when a bill of lading is endorsed from the shipper holder onto the endorsee. And what this case was testing is when before the bill of lading springs to life, is it actually already in existence and just in some way sitting to the side and then is revived on endorsement? Or does it, is it born? Does it, for, purposes of being a contract, does it come into existence and come to life on endorsement?
And just in case we haven't truly hammered home why that's fundamental to this case, that is because BP endorsed that bill of lading onto UniCredit. I think they did so considerably after the events had taken place. And by the point that BP endorsed on that bill of lading, the novation had already taken place. So the usual way round is, of course, that BP have both the charter party and the bill of lading in their slightly oily hands. And what they do at the next stage is that they endorse on the bill of lading. So when the bill of lading goes, they're still the charterer, and the bill of lading springs into life, as Lucas just said, and all of the rights get sent on. The problem here is that at the point the bill of lading gets endorsed on, the charter party is gone. The charter party has already been novated away. And that's what, for anyone who enjoys a trip through old bits of case law and textbooks that you can no longer get hold of, necessitates a really deep dive into how does that happen? Everyone, as Lucas said, accepts the idea that at the point the bill of lading gets endorsed on, you get this transfer of rights taking place. All of a sudden, if you are firstly the receiver of the goods, or sometimes that financing bank in the middle who thinks he's taken security, what you think you can do with that bill of lading is say, well, I've got a package of rights against the ship owner. I can collect the cargo, I can bring a claim for short delivery, damage to goods, or crucially here, and this is the bigger picture point about what the bank was doing, for delivery without production of original bills of lading. Because when those transfers of cargo by ship to ship took place into the Cutch Bay and the Prestigious. What didn't happen was either of those sub-buyers produced the bills of lading to say, this is mine. They couldn't do that because the bill of lading was stuck in the middle of that financing chain. And that's why this issue came to the fore. We'll touch on that slightly later on. But firstly, in terms of how you go about working, what rights get passed on, the fundamental point that comes out of this is probably twofold. The first point is one of those really old common law adages, the sort of thing you do on day one, week one of law school, which is you can't give what you haven't got. And the same applies to title to a used car or title to a cargo of oil, or indeed rights under a bill of lading. If at the point you transferred it on, you didn't have those rights, then they can't miraculously come into being by endorsing on a bill of lading. And the second thing that comes out of this is actually the legal basis for rights under a bill of lading being effective in the hands of that cargo receiver that we just talked about. And as I think Luke might explain better than me, that there is a sort of legal fiction, the court decided, that is really what takes place. And that by virtue of common law followed by everybody's old friend COGSA, effectively, even if it doesn't really work on a number of true contractual or legal analysis, everybody agreed that that's actually what happens. And that has then been codified. And that's what gives this idea of a contract springing into action its force.
Yeah. It's an interesting one. It really makes you think about what is the status of the bill of lading at any particular time, and what can parties do under it. And I've got to say, it's not something that's kind of intuitive. Bill of ladings and how they're negotiable and how they work takes some mental wrangling when you first come into this area of law. For us who've been dealing with these for years, a lot of these concepts become second nature, and we just kind of take them as read. And one of those issues is this concept of a bill of lading only being a mere receipt in the hands of the charterer. And why that is, why is it that the bill of lading isn't more than that? And when you think it through, it's like, well, the bill of lading is a document coming into existence at a later point in time than when the two parties to the original contract of carriage, the charter party, had already entered into it. So the owners and the charterers have a contract between them. They have set out their rights and obligations in that charter party. And then practically what happens is someone comes along under that charter party, performing it, if you like, and puts some goods on board the ship. The owner then issues a document, a receipt, to say, I've got these goods and I'm going to give that document to the shipper, the party that's put the goods on board the ship. Now, if that shipper is also the charterer, there's no good reason why in acknowledging that the owners have brought the goods on board the ship, that they should change the contractual relationship between owners and charterers. And it makes a lot of sense to say, well, just because we've now received the goods, we're not going to change the contract between us. So, okay, the bill's been issued. It's in our hands as let's say we're shipper charterer. We haven't changed the contract between us. So what does this document actually do? You can see why, and the rationale when you kind of think it through about what is happening practically, that the bill of lading should not have the status of a contract of carriage, because that could be changing the obligations and the rights between the owners and the charterers just because they've received goods on board.
And this is why, of course, you then get into that difficult hot potato of the bill of lading incorporating the terms of the charter, and when it is endorsed on. And that this highlights why that is so important, because the bill of lading is fundamentally a different document, but all those exceptions which the shipowner wants to rely on, and the shipowner can obviously rely on facing the charterer to begin with, all of a sudden, at the point where that new contract springs up and is endorsed on, and this stuff is in the hands of the bank or the cargo receiver, who's coming after the shipowner and saying, I didn't get my cargo of sugar, it wasn't right, it had gone off, that's where it's going to want to rely on some of those things again. And that's where you get this really important disjunct between the two contracts, and one being the contract of carriage. The shipowner needs to know which the contract of carriage is. It's fundamental to its operation.
Yeah, and it's interesting that when you think it through about, you've got this original document that's then in the hands of the shipper and the charter that's been issued. It exists. It's been signed, stamped, delivered. It's sitting there in the hands of the shipper charterer. But two functions of that bill of lading that later come into existence, that it is a contract of carriage between holder and carrier, and that it's a title document, only come into existence after they're passed on. So it's almost like the shipper charter is holding on to this document that only where it passes it on to a proper holder or endorses it onto a proper holder, that it gets these other elements to it. It's the other functions come into existence. So, and this is really what half the judgment is about. It went through and explored the claimant's contention, so the claimant bank, its contention that when the bill of lading had been issued and was in the hands of the shipper charterer, that it had temporarily lost its full contractual status. And that was the pleading, that was the argument that the bank was trying to develop. And the courts went through and looked at the various authorities here, went through, as you said, through the textbooks and cases going back to the 1800s, which talk about the bill of lading as a contract of carriage springing to life. And so when you think about it practically, it is very much that this document hasn't got all of its functions yet. Just because it's in the hands of the shipper charterer, it hasn't actually got all its functions. And that comes into existence because of the very act of endorsement. And you actually need endorsement, and you need that process for the birth to happen, for the bill of lading to become a contract of carriage.
And this is where you've got to give John Russell QC his due for the inventiveness of the arguments that he tried to run here. But the argument they tried to get home on is the idea that rather than springing up, actually what happened is the contract was merely suspended or was in abeyance, whatever that actually means in legal terms, and was so capable of being revived. Of course, if there was something there which was suspended, then the bank could give it. Then BP could give it, because actually it had something to pass on. But and this is where it's interesting to see the extent to which Mrs. Justice Mulder was carried by an extract from Carver. Carver is my favourite textbook. I can't speak for Luke on this one, but it is brilliantly clear. And what they set out there...
I'm not going to argue with you.
It's sad to have a favourite dry shipping legal textbook, but Carver's mine. It is that it talks about the way in which Cogs in 1992 approaches this. And that, as some people listening will know, is what provides for the transfer of rights to the transferee as if he had been a party to the contract contained in or evidenced by the bill of lading. And what it goes on to say, when you track through the history of the 1992 Act, is the idea that actually what takes place, this idea of the contract springing up, is basically a legal device invented to avoid what's otherwise a really commercially inconvenient result. Actually, what ship owners and charterers have been doing over the years, and what the 1992 Act did, is codify a bit of legal fiction. And that's why it works. It's a bit like riding a bike for the first time. You've just got to accept that it does. It's quite hard to say why. And it's fundamental to the outcome of this case. But the second thing that is fundamental to this case is the issue which was run alongside. So it was decided on that point. It was decided on the basis that at the point the VP endorsed this bill of lading onto the bank, it couldn't give the rights to the bank, which the bank was then seeking to enforce against the ship owner. And as a result, the claim failed. It would have been lovely for the purposes of this podcast if the judgment had stopped there, but actually the remaining, I lose track of how many paragraphs are spent going through the evidence of and you can't help but feel a bit sorry for the sort of operations and back office team at the bank here. Poor Ms. Bodnia, who had the unenviable task of trying to keep track of a sort of sprawling email inbox with different people trying to sell different bits of oil to other people, all in the context of a financing agreement, which the bank, I think we came out in evidence, wasn't really being terribly strict about enforcing the terms of. And all this was taking place at the point that COVID had really hit the world hard. And so everybody was scrabbling to make normal operations take place.
Yeah.
That was the background to it. But the reason all that is so important is that, and this is a very good argument that was run by Rob Thomas, QC, and Preston Turnbull, was that, well, hang on, even if that contract that got passed on existed, let's say it was in suspense, it was in abeyance, there's a big causation problem here. You, the bank, were never going to insist on there being production of original bills of lading anyway. And so it doesn't matter. And actually the key point, and Mrs. Justice Mulder gives an admirably clear summary right at the end of the judgment in relation to this, is that firstly, in the oil trade, most cargoes are discharged against a letter of indemnity to protect the ship owner against the fact that no original bills of lading have been tendered. As I'm sure many of you have dealt with day in, day out, that this is common practice. There's a set form that you use. And at the point that the bills of lading are stuck in the financing chain, the ship arrives, you don't want to sit on demurrage forever and a day, so you're going to get on and discharge. What protection does the ship owner need? Well, the ship owner needs to know it's discharging to the right person. Because otherwise, if it discharges the cargo to the wrong person and the lawful holder of the bill of lading turns up with all of those rights that have been endorsed onto it that we just discussed, then the ship owner is liable for failure to deliver. So that's why you get the indemnity in place. It doesn't quash the rights under the bill of lading. It gives the ship owner someone to go after and get paid by if that claim turns up. So what the bank did here was say, well, look, you should have asked for that original bill of lading. You shouldn't have given the cargo away. And that just didn't withstand detailed assessment by the court, because under the financing agreement, delivery of the cargo always was going to be without production of original bills of lading, because, and I think it might actually have been written into some of those documents that was the case, and that there is the most sort of fantastically toe-curling series of submissions that get made here about the difference between authorization to discharge by STS, authorization to discharge by STS without production of original bills of lading, and something called a general authorization, which I think is something that's just been invented along the way to try and bridge the gap here. What the bank was desperately trying to do was say, if the question had come back up the line to us, so the ship owner had said to Gulf, look, you've told us to discharge, where's the bills? We're not going to do it. Gulf, under the terms of its financing agreement, would have had to say to Unicredit, can we do this? It's a financed cargo. Can we put this out to our sub-buyers without those original bills of lading? Mrs. Justice Mulder said, well, basically, you were going to say yes. You were always going to say, go on, discharge into those two other tankers. It's all probably going to be all right. And there's all sorts of reasons for that, not least the fact that the correspondence, and this is where it's interesting legally when it comes to how a dispute runs to see the difference between what a perfectly credible witness said in the box and what the correspondence suggests underneath. And this is a pretty brutal example of the fact that the call will almost always go to the underlying contemporaneous correspondence as the best evidence of what you thought you were going to do at the time. And here the documents show really quite clearly that the bank was going to agree. It wasn't fussed about this at all. It always agreed. And so, as a matter of causation, the claim failed anyway. It didn't matter if the bank had got the rights to claim against the ship owner. It was always going to agree. And as a result, the claim failed 2 ways.
Yeah, it's a practice that I've wondered about many times. It's also something Callum and I have talked about in prior podcasts, and that's the practice of writing into charter parties that delivery will happen without production of original bills of lading against an LOI. And sometimes that's a blanket agreement at the outset and really undermines the whole purpose and function of the bill of lading. And it's always surprised me how those clauses seem to be agreed for efficiency reasons, to speed things along because the bill's not going to get to the other end in time, or it's just going to be complicated, without thinking through, well, what happens if there's some dispute along the way about who's the proper holder of the bill of lading? And I don't think we know the ins and outs of the finance, package as well here as we might in some other situations, but we see it regularly, this clause appearing where there's agreement at the outset to just go ahead and deliver without original bills against a letter of indemnity. And when you're then faced with a problem, if you've already agreed in advance that you are going to go ahead against a letter of indemnity, what do you do if, the party, the charterer that you've agreed to deliver against their LOI is a bit susceptible financially?
Which is exactly what happened here.
What do you do? You've agreed to go ahead. You've agreed to go ahead against an LOI. And that's the danger in pre-agreeing to do something. You might decide to do it down the track. You might get to the point where the bills are not available. They haven't made it to the delivery port in time. There's a request that goes into the owners to deliver the cargo without the bills being present and handed up. And the owners turn around and say, okay, we'll do it against a letter of indemnity. At that point, you hold the cards. You can assess, well, do we get a letter of indemnity countersigned by a bank? I know that's what's the best practice. Hard to do in reality, but you could ask for that. You could size up if it's going to be a corporate guarantee from an individual chartering entity. You can weigh up, do they have any assets? Are they good for the LOI that they're issuing? Can it be backed by a parent LOI? What room do you have to maneuver? You can do all that if you haven't already pre-agreed. If you've pre-agreed, it's difficult. It's difficult because you're undermining one of, if not the main functions of the bill of lading and the protection you get in insisting on original bills.
Because the real unknown here and the big commercial problem on the point that Luke was discussing is that assignment of the charter party from BP, who are a lovely person to have got an indemnity from, to Gulf, who were a horrible person to have got an indemnity from and legally had become a man of straw by this point. And the whole point about the letter of indemnity regime as protection for a ship owner is the indemnity is only as good as the person giving it. It doesn't affect the rights under the bill of lading at all. It's just protection that you have to go after, but like insurance. And that's where people often come slightly unstuck. But the really interesting point, I think, that comes out of this is actually the bit that's usually not discussed in all the bill of lading cases, and that's the role of the bank as a trade financing body taking that bill of lading in the middle of the chain. And it's really unusual to see a bank coming in as a claimant under a bill of lading in this way. This doesn't really happen very often. And the role of the bank is actually something that can cut both ways here. Now, I know that that this is one of Luke's specialities. But the thing you need to remember about that transfer of contractual rights under a bill of lading is that it's not just an assignment. You are passing the benefit and the burden of the contract of carriage, which means that if there's been a failure to pay freight, then the ship owner might get to the discharge port and he's got the cargo on board, and he can make a claim for so-called bill of lading freight from the receiver. At that point, the receiver's got to pay the ship owner the money that the ship owner was due to carry the stuff across the ocean if he's going to get the cargo off. Now, he's going to go bananas at that point because he's going to say, but I've paid this under my sale contract. I've paid a price for these goods that includes the carriage. What do you mean I've got to put my hand in my pocket again to get the stuff off? Well, he's got a claim against the guy that he's bought it from at that point. But in that sort of merry-go-round of contracts, often those two guys haven't got very much money at all by this point. The person that does, however, is the bank in the middle. And as we've demonstrated from looking here, and you can almost hear the panic from UniCredit sitting around coming up with any strategy to make a recovery on their security package. The problem for the bank here is that as that bill of lading goes down the letter of credit chain, they do, in normal circumstances, become fully entitled to the rights and the obligations thereunder.
Yeah, exactly. It's a fascinating area of law. I could give a number of anecdotes on this. One is that I'm not sure you're even aware of this, Joe, but the firm ZFZ actually has a big kind of debt of gratitude to misdelivery claims. Ed and I originally crossed paths on a massive misdelivery claim where we were on for owners, delivered without presentation of bills, tried to claim under a corporate letter of indemnity from some Swiss charterers that said, nope, we're not going to pay. And we were on for owners. They had a sister ship arrested in Morocco. We tried to challenge that. I think the cargo should have been delivered in Dakar and ended up being delivered in Mauritania. We were scratching around trying to find some assets of the charterers, and eventually Ed, so I was sitting in London at the time at a prior firm, and Ed was in New York long before the firm had kind of set up, and Ed managed to pull a rabbit out of the hat and found a insurance claim, a trade credit policy insurance claim for like $10 million, which was only a litigated claim at that point, attached it under Rule B in the US. And then in the course of, running the dispute for the attachment, it turned into a judgment of 10 million. And they then came to us and said, okay, here, have your security. We want the rest, because we'd tied the whole thing up. So it was a really, it was a really interesting case, that one, and how Ed and I originally met. And then, the rest is history, as they say. But coming back to your point about COGSA 92, another matter that I've dealt with before, and I've had a few like this now, where when you're looking as a carrier or even as a disponent owner, charterer in a charter chain, looking up the chain to see what you could ask the carriers to do, and that's a different topic which I won't get into today, but just being in the shoes of the carrier under the bill of lading for that unpaid freight claim, as you described earlier, what you're looking for is, who can you pin that on? Who is the other party to the bill of lading, the receiver, let's call them, or the holder is probably a better way of putting it, that as the carrier you can claim against. So who is liable under the bill of lading? And there is an act that codifies this, as Joe mentioned before. It's COGSA 1992, and it's Section 3 that deals with this. And if a party has done one of three things, if they've either taken or demanded delivery, if they've made a claim under the contract of carriage, so under the bill of lading, or is a person who at the time before those rights were vested in them took or demanded delivery. In those three instances, if a bank has done that, and we have seen cases where a bank has stepped in because their borrower has gone under or are in the throes of going under, and the bank wants, in its, anxiousness to get security and exercise its security, has the bill endorsed to them, and the bank actually hands over an endorsed bill to them, to the carrier, there's a good argument to say that they are the ones who have taken delivery or demanded delivery for the purposes of Section 3. And in that process, they can become exposed to the unpaid freight claim that may arise under the bill of lading that the carrier has against the holder. Whether it's limited to freight is an open question. We're looking into other arguments around whether demurrage or damages are possibly recoverable under that bill of lading. More tenuous, but again, a discussion for another time. But I really think that area of bill of lading law and shipping law is underexplored. And I think there's more to be said on that, and we will see more of that in the future. So look, with that, I just wanted to thank Joe for coming on today. Did you have any other parting comments or thoughts before we wrap up?
Just to say thank you for having me. But remember, everyone, bills of lading are fun. They're really interesting. And if you want to talk more about them, you know where we are.
Very good. All right, Joe. Thanks for your time. Look, if you've gotten to the end of this, well done. We've gone through some weighty shipping law topics today. So thank you for listening in. We hope you found this useful. Please do like, subscribe, follow us on the usual places. And until next time, take care.
Goodbye.